Good afternoon, ladies and gentlemen. Welcome to this seminar organized or co-organized by our Faculty of Law, Hong Kong U, together with the Hong Kong University Graduates Association and also the Hong Kong U Law Alumni Association. And I will introduce to you the representatives in due course. Our Faculty of Law has, as one of our research centers, the Philip H. Wong Center for Chinese Law. So this event is also an event of the Philip H. Wong Center for Chinese Law. The event is a dual mode event. So in addition to those of you who are here, we are also joined by members of the audience online. And I think the number of those who are online actually exceeds those who are physically present. But when we come to the discussion period, we'll of course give priority to those of you who are physically here. The topic for this seminar was actually suggested by one of our speakers here today, Mr. Rico Chen, who is also the president of the Hong Kong U Graduates Association. So he is a graduate himself of our law school in the late 1980s, and he has a very distinguished career as a practicing solicitor. And he suggested that maybe we should explore this theme, this topic of common law, continental civil law, and economic development. Mr. Rico Chen has been acquainted with another of our speakers today, Professor Li Honghai from Peking University, who actually has for many years taught a course on the common law system at the Law School of Peking U. And actually one of our colleagues, Professor, one of our colleagues, I don't think he's here today, but there's Professor Xiao Weilin, who was actually Professor Li's student when Professor Xiao was a student at Peking University. So the two main speakers for this topic today, in addition to Professor Li Honghai, is of course a very distinguished member of the Hong Kong U community, Professor Richard Wong, the Provost and Deputy Vice Chancellor of the University of Hong Kong. And we are very fortunate and privileged to be able to have Professor Wong with us this evening. Professor Wong has actually written widely on, among other things, this topic of common law and economic development, particularly development as an international financial center. So the topic is very relevant to Hong Kong because, as you know, Hong Kong is an international financial center, and according to China's plan for its development, in the latest 5-year plan, Hong Kong is expected to play a further or increasingly important role as the international financial center in the foreseeable future. And as we all know, Hong Kong practices the common law system. So we are all interested in whether the common law system actually helps Hong Kong as a financial center. Then we will also have, as our discussants today, two very distinguished members of Hong Kong's legal community. Dr. William Wong, Senior Counsel, who has been serving as a member of the Basic Law Committee of the National People's Congress in recent years. So he is a leading authority on not only Hong Kong's common law, but on the one country, two systems and the basic law. Mr. Rico Chen himself, as a practicing solicitor, will also serve as discussants. So we have two discussants in addition to two speakers. So without further ado, may I now invite Professor Wong to deliver his speech. Thank you.
Okay, thank you, Professor Chan. And let me say at the outset, I'm delighted to be here. I'm sorry to inform you, I actually haven't done any research on common law and economic development. I'm not a student of law. I've not taken any single law course. And although Professor Albert Chan very generously said that I have written about these things, these are newspaper articles that I published during the time when I was less busy in administration. And everything I published are not my ideas. I was just describing for the lay public some research that I am familiar with because I read journal articles. Okay. So I am going to cover, given the time, I'm going to cover only 4 topics here. The first is a little bit about the economic analysis of law. I'm going to talk about the work of a number of people: Learned Hand, Guido Calabresi, Ronald Coase, and Richard Posner. And then this is to get you to the point where by economists or lawyers who study the interface between economics and law came to the view that the common law was better for economic development, right? Then Andre Schleifer, who is a professor at Harvard, an economist, did very original research that is the legal origins theory, comparing common law and continental civil law and why they have different impact on economic development. I think the research on legal origins has pretty much now stopped or stagnated because I think everything that's worth and can be done has been done, at least for the time being. Then I present some evidence about law and finance. I'm going to skip the part by Edward Levy on an introduction to legal reasoning because that would take us a very long time. But that basically, Edward Levy's work is actually also very foundational for those work. And finally, I will make a few comments on Hong Kong's role as China's international financial center. Justice Learned Hand in 1947 developed a formula that defines negligence by balancing the cost of precautions against the expected risk of harm. Liability exists if the burden of taking precautions is less than the probability of harm multiplied by the gravity or magnitude of the injury. So he developed a formula and said B is less than P times L. B is the burden, P is the probability, and L is the injury. Right? He actually gave a formula and said this formula should determine how the assignment of negligence should be done in a court. This is the first time a justice of federal court actually came up with an economic formula, right? So the next is Ronald Coase, who's worked in the theory of social costs. A paper published in 1960 showed that the social cost of economic externalities could in principle be corrected through markets, provided the legal system can properly specify and enforce property rights at low transaction costs. Low transaction costs is important. If you have high transaction costs, then you cannot have a market to settle these disputes, and therefore you need legal rules to assign, right? So, but what it did was he actually opened up the opportunity to apply economic analysis to the study of legal institutions. So his work is pivotal to the law and economics literature. Guido Calabrese, who taught at Yale in 1970, argued that accident law should minimize total social cost. So accident losses, prevention costs, administrative burdens, all these included, and how you minimize total shock by assigning liability to the cheapest cost avoider rather than to the party deemed morally at fault, making efficiency rather than culpability the organizing principle of tort law, right? So Guido Calabrese made a considerable extent. Then perhaps the most influential in creating the area of economic analysis of law is Richard Posner. Again, a federal court judge. His foundational contribution was extending the economic reasoning across all of law, arguing that common law rules implicitly promote efficiency. And therefore, wealth maximization should be law's normative goal, right? And that even judicial behavior and non-market domains like family and criminal law are amenable to rational choice analysis. One does not have to believe and be convinced and persuaded that Richard Posner is correct, but it is also a compelling case to argue for that the legal system, and particularly the common law system, the rules are designed to promote efficiency. This is fundamental to the argument that common law is better for economic development, because common law promotes efficiency. Now, one may say, I don't believe it. That's okay, right? I know most legal scholars don't like Posner very much, unless they are Posner students. But that's fine. But this is the case, right? He made, and of course, many have made that cases before him, but this is the most comprehensive. The next is the theory of legal origins. The theory of legal origins basically is created by André Schleifer, professor at Harvard University, who tried to understand the origins of civil law, continental civil law in France versus English common law, and why common law and continental civil law are so very different. And he develops a theory, a model. You know, when economists develop a theory, it's always a mathematical model and to show why that happened. And as a result of that work, he basically say legal origins, that whether it is civil continental law or whether it is common law, has consequences for the type of legal institutions that are established. And these legal institutions, which originate from which type of law tradition, has consequences or have consequences for economic outcomes. For example, right, procedural formalism is more so in one legal tradition. This has an impact on the time you can evict a non-paying tenant. So you can go and empirically test whether it's easier to evict a non-paying tenant in a common law jurisdiction versus a continental law jurisdiction. Time to collect a bounced check, which takes longer. Then you have judicial independence, and judicial independence protects property rights. Regulation of entry, right? Competition law, for example. Does that lead to, in common law, therefore less corruption compared to civil law systems? Whether the unofficial economy, that means the shadow economy, the economy that cannot legally present itself in a court, including criminal behavior. The unofficial economy, is it bigger? Is it larger in continental legal systems versus common law systems. Government ownership of media, is it stronger in common law versus civil law? Labor laws, are labor force participation rates, is unemployment rate, are they higher in common law or in continental law systems? Company conscription. Conscription is more extensive in continental law versus common law. Very easy. The United States does not have conscription. For example, it was repealed after the Vietnam War. Company law, securities law. Are stock markets more developed in common law? How about the valuation of the firm? That means things like price earnings ratio. Are they higher in common law jurisdictions? Ownership structure. That's better protection for shareholders. I cannot read that, okay? And the control premium. Bankruptcy law. Is it more common to have private credit in which legal system? Government ownership of banks. When it's obvious that in continental law, there's more state-owned banks than in common law. And as a result, the economic consequences, they spread, the gap between deposit rates and lending rates is higher in continental law systems than in common law system. Just very easy. On the mainland, the spread is larger than it is in Hong Kong. Right? These are the legal origins theory. Look at the legal system, look at the legal institution. I should rephrase, look at the legal tradition and the legal institution it inspires, and what are the economic outcomes. So the legal origins theory spawned many professors and many graduate students to do a lot of research. So hundreds of research has been done across many different countries, and by and large, they claim, the literature claims, this is all verified, right, empirically. In the world today, many countries' legal systems have their legal origin either because of the continental system in France, and France conquered much of continental Europe, so their system prevailed on the continent, whereas the common law is very much Anglo-Saxon and also bequeathed onto common law countries, onto their colonies, Hong Kong being one of them. So Hong Kong is common law, whereas Macau is continental law by virtue of Portugal, and the province of Taiwan and the mainland is very Germanic law because we adopted the Japanese choice and the Korean choice and all these reasons. So we have developed these, and these systems, once migrated, transplanted, have a life of its own. Okay. So this is the spread, right? There are more continental civil law systems than they are common law systems as a whole. Okay, now here is the trick, right? So I'm only going to do one thing, and that is look at the stock market capitalization. How much is the stock market valuation divided by the GDP of that country in civil law versus common law. Civil law, meaning civil, continental civil law and common law countries. This is periods between 1900, 1929, and all the way to the more current period, 2008 to 2025. The blue bar says the stock market capitalization per GDP is higher than in the green bar. And the blue bar represents the common law countries, the green bar, the continental law countries, continental civil law country. And this is consistent for nearly, shall we say, 200 years, right? 200 years, right? And the countries I've listed on the bottom covers those civil law and common law countries that have stock markets. An interesting thing is the following. Let's see the next chart. This is the stock market capitalization over GDP in China versus India. And again, you notice the stock market capitalization per GDP is higher in India than in China. And the point is, if you invest your money in China versus invest your money in India, the Bombay Stock Exchange, you would have made more money by investing in the Bombay Stock Exchange than in the Shanghai or Shenzhen Stock Exchange. All right. What's the difference? Well, you can have many reasons. The legal origins theory says it has something to do with the legal tradition. The data is actually quite compelling in many different areas. And it impacts not just finance, but economic, social, and other behavior. Now, you can argue whether these works have been done vigorously, and so forth, but that's not the purpose. So I'm going to move a little faster because I know my time is up and I should not take all this. But the big difference between the legal origins of the two is civil law is policy implementing, whereas common law is more dispute resolving. Civil law and continental civil law embraces socially conditioned private contracting, whereas this is civil law. Contrast with common law's tradition, which support unconditioned private contracting. State does not come in until absolutely necessary. Encourage private parties to settle. This approach is very difficult to change once you have a legal tradition. So legal origins theory basically says the political conditions in England was different from the political conditions in France, and therefore they developed rather different legal traditions. And the most important fact is that to have a legal system that is fair, the most important thing you must achieve is that you must protect those who are judges and lawyers so that they do not get harassed or corrupted by the litigants. And how to protect the judges and the lawyers created different legal systems, legal traditions. Now, let me move on to very quickly and conclude. This is Hong Kong. This is a map of Hong Kong. This is a very familiar map of Hong Kong. This is a map during the period, right? We all seen this map. This is the typical map of Hong Kong. And during the period 1842 to 1997, Hong Kong was under British rule. I actually found a map. This is a map drawn in 1879 after British rule. This is Qing Dynasty. And the map looks reasonably familiar, like the modern map we have. Right. Here is a different map. This is a map of Hong Kong inverted. You notice, right? If you sit in Canton or you sit in Beijing, if you look at Hong Kong, this is what you will see, right? It's the reversed. So before 1842, and the interesting thing is, this is the Ming Dynasty map. This is before Hong Kong was ceded to Britain in 1842. And this is what it looked like. Of course, it's a bit inaccurate because Hong Kong looks like a very small island. But actually, you notice the larger island next to Hong Kong has all the areas that Hong Kong Island has. So the drawing is not actually entirely accurate. I think they must have, so probably they mistaken the area of Lama Island as Hong Kong, right? So it looks reasonable. The names of the places are quite traceable, right? Many of them are similar to the present day. So what I am trying to say is, what is the role of Hong Kong in the 15th five-year plan? Very clearly about financial market development. Consider the following. Just look at the the recent history of China, we had a property market crash. The property market crash is still with us. It has not out of words, but the government in China, mainland China, chose not to save the property market. Instead, it chose to channel those resources into technology and manufacturing. And what has it created? It has made China's manufacturing sector very, very competitive. And the 15th five-year plan has continued to urge the country to do that. China, the government of China, can use its state powers and its fiscal system to mobilize all the resources within China to support the manufacturing and technological sector. But the fiscal system can only mobilize the savings in the People's Republic of China. The United States, through its financial markets, can mobilize the resources for everyone who wishes and feels confident to invest in the United States. The financial market can do things beyond the fiscal system. I think it's quite clear in the 15th five-year plan. China wants to get Hong Kong to do all their fundraising from the rest of the world, which they cannot do with their Shanghai and Shenzhen stock exchanges. I'm not saying Hong Kong will succeed, but at least that's the plan. Perhaps the only advantage we have in Hong Kong is, according to the interpretation here, is our common law system. Thank you very much.
Thank you very much to Professor Wong. Here in our law school, we teach many courses of law, but I think very few courses, if any, touch upon the topic of the seminar today. And I think Professor Wong's speech is very enlightening for law students who have not heard about the series which Professor Wong has just introduced to us, including theories about law and economics and theory of legal origins. I think students know about the distinction between the common law and the continental civil law, but probably not the research which has been done on how these different legal traditions and systems may impact on economic development and financial markets and so on. So let me now turn to the second speaker, because when we organize the seminar, we want to also introduce a perspective from the mainland. And Professor Li Honghai is the ideal speaker on this topic from the mainland because he has been trained as a legal academic in the mainland. He has been a visiting scholar in Britain and other Western countries. And he has taught generations of law students in Beida about the common law system. So I understand that Professor Li is speaking in Putonghua, but every one of you who are physically here should have got the English version of Professor Li's speech. And also for those of you who are online, please note that we have got Zoom simultaneous interpretation. So you can just turn on the English version of the Zoom system and you can hear the machine translation of Professor Li's speech. So may I invite Professor Li to speak.
谢谢陈老师。非常抱歉，我英语说的没有那么流利啊。为了非常有效的表达我的观点，所以我选择用普通话来说。我相信AI 的翻译要比我说英语说的更好啊。 我刚才跟王校长交流的时候，王校长说他没有做什么研究，我当时就心宽了很多。但是他一讲，我发现他做的研究比我做的多，然后我又紧张起来了。但是我对这个话题确实有很多有一些想法啊。我和王校长可能不太一样的地方，我会从一个法律的角度，从一个普通法自身的角度来探讨，为什么说普通法会比civil law 会更能促进、更有利于经济的发展这一点啊。其实关于这个理论，我们先前已经有过很多的讨论，比如说大家都很清楚的 LLSV 学派。他们就探讨过，做过很多的实证的研究，发现普通法国家的经济发展会比 civil law countries 的经济的发展会更好一些。然后，我的一个朋友，他专门研究1870到1940年代上海经济的发展，然后他用了当时的政府的官方的数据，以及申报和其他一些媒体的数据，来看当时那个债券、股票的发行以及交易的这个活跃程度、数量。你会发现，公共租界就英美租界，它的这个活跃程度是最好的，然后是法国租界、法租界，最后才是清朝控制的这个地区啊。所以有很多的经济学家在做这样的研究啊。但也有一些比如说我们王校长也是在做这样的研究，而且他刚才展示了一些内容是他先前文章当中所没有披露的啊。所以这是我说他为什么又做了很多研究的这个原因所在啊。然后还有一些法学家也在做类似的一些研究，比如说像这个那个什么，王老师刚才提到的，波斯纳呀然后卡拉布雷西呀然后像这些人，但是包括像前2年那个诺贝尔奖获得者，他们写那个为什么有的国家会失败那本书的，然后他们也披露了，所有的这些理论或者说结论都会指向一个东西，也就是说政治制度或者说制度它的质量，也就是制度它的这种组织形式，会严重的非常从根本上影响经济的发展啊。那么我今天想讨论的呢，我是想从一个法律技术的角度 （technical perspective），然后来讨论为什么说 common law 会更有利于经济的发展，会比 civil law 更有利于经济的发展啊。那么要讨论这个的话，我想先有几点我要先澄清一下。第一个就是经济和金融啊，广义上来说，我是把金融视为经济的一部分啊，因为金融有它独特的发展历史啊，比如说跟犹太人它的发展有关系啊，尤其是跟英国意大利商人这些发展都是有很大的关系的。我们不再追溯它的历史啊。然后呢，就是所以我是广义的说经济的这个事情，而不是说专门说金融这个事情啊，这是第一个啊。第二个呢，就是说这个看一下哈。我们说经济发展它需要的条件，我们需要从经济发展这个条件来说，一个地方它经济为什么会发展的好，为什么发展不好？我们知道经济发展它需要的基本条件，比如说它需要有资源，需要有能源，需要有劳动力然后需要有智慧，就是科技需要有这些，然后还需要有资本还需要有组织的这些能力但是这些东西它对经济来说重要不重要？非常的重要，没有这些东西，经济就不可能发展但是这些东西它是可替代的，也就是说，我们把这个华南的这些因素可以转移到越南去可以转移到西欧去，而且历史上也在发生。石油虽然说中东很多，但是别的地方也有然后所以资金莫斯科的资金很多，但是别的地方资金也很多所以我的意思是说，这些因素它其实都是可替代的所以它对经济的发展，从这个意义上来说，它对经济的发展不是根本性那什么才是根本性？我认为其实是法律和政治的基本制度因为这个东西如果说把它抽离了，你就会发现有的两个不同的地方，资源完全都是一样的，但是他们经济发展的情况是不一样的。这个在为什么国家会失败那本书里面已经说的非常清楚了，我就不需要再说了 所以我今天我就是说要解释这个问题，从法律技术的角度解释这个问题。第一个，我想从3个方面来解释。第一个，普通法它可以提供一个更加自由的环境，从而更有利于创新啊，这是第一个。第二个，普通法它非常注重落实，不是说了空话之后，然后就列了一堆权利，结果后来啥都没有，而是说他列了这个权利之后，他会把它落实的啊，这是第二个。第三点，它可以制约公权力。我会从这3个方面，但是我会花更多的时间在第一个方面啊。为什么说第一个方面？我想说的是，普通法它有利于自由和创新。为什么？因为普通法它是 case law 啊，它是 judge made law。那这个意味着什么呢？意味着它不是事先制定出来的啊，就是王校长刚才说的，它不是，就是那个制定法，它是 policy implement 啊，它是我有想法，然后我把它制定出来啊，大家都去执行。那判例法，它是为了法官法 judge made law， 它是法官在解决问题、解决纠纷的过程当中，然后寻求了一个解决方案，这个解决方案当中它蕴含的规则。所以我通常会说，普通法、法官法，它是一种什么样的法律呢？它是专门针对这个纠纷而给它量身打造的一套规则。我把它称为叫量体裁衣。法官运用他基于这个案件的事实，然后基于相关的制定法的条文，基于相关的先例，甚至可以说考虑到宗教规范、道德伦理都可以啊。然后他基于这些材料，基于这些布料，然后为这个事实打造一套适合于他的衣服。而大陆法是什么呢 ？Civil law， 它是那些衣服已经做好，已经挂在这个地方。然后当这个纠纷来的时候，法官只要给他选一件最合适的衣服就可以了。如果我们找不到最合适的衣服，那我可以给他裁边，可以给他放一放，收一收，然后这就是法律解释。通过这种方式，但是无论如何，这个衣服是已经做出来，已经挂在那里，他找到这件衣服，然后给他披上啊。所以它不是量体裁衣，我把它称为叫选购成衣，已经做好的衣服挂在那里，我把它选出来，是这么一种机制。所以那个法律是已经先存在了，但是对于普通法来说，它其实是事后的，而纠纷发生以后，然后我找到了这个规则。所以从这个意义上来说，它是 retrospective， 也就是我们所说的溯及既往的。普通法的规则本质上来说，它就是溯及既往。这也是边沁为什么称之为 dog law 的原因所在。为什么会批评到 dog law 的原因所在啊？但是它的这个特点却保证了一点，也就是说什么呢？它不会事先给你立规矩，所以你有很大的空间，你来做决定。在面对这种情况的时候，我来怎么做？这就给了当事人他自己做决定的巨大的空间和自由，而不是如果制定了规则在先的话，那就意味着我必须得按照这个规则来执行才行。那这在一定意义上，在有些情况之下，会很大的意义上会制约当事人他的自由，从而一定会影响创新，一定会影响人们的冒险精神，然后他的企业家的精神，他一定会影响。那所以这是我为什么说，作为 judge made law 的普通法，它为什么会有利于自由，有利于创新啊？但是自由和创新并不意味着它就一定会一团糟一团乱。为什么呢？因为如果说，因为正是因为你可以自己做决定，所以当我让你在为自己的决定承担责任的时候，我才有了正当性。我没有让你做这样的决定，是你自己做了这样的决定，所以你应该为这样的决定来承担责任。所以越是给你自由，同时就意味着你应该来承担责任。自由和责任就像一体的两面，这一面是自由，但是这一面是责任。 就像太极图一样，这边是阳，这边是阴，这边是自由，这边是责任，它是不可能说我只有一面的。那基于这个道理，或者说基于这个原理，我们会发现，普通法它不仅有利于自由和创新，而且还有利于培养有责任、有担当的公民。那如果要是说我已经给你制定好了规则，那就意味着在一定意义上意味着我替你做了决策。那如果说我的决策是你替我做的，我为什么要为这个决策承担责任呢？所以，也许大家会批评我，但是我还是想说，在 civil law 的制定法、成文法的体制之下，你会发现，它可能不是那么有利于培养有责任心和有担当的公民啊。那么基于这2点，我会认为普通法它会更有利于企业家精神的这样的一个培养，自由、创新、责任、担当，这些都是对企业、对经济发展来说非常重要的因素。这是第一个。第二个，我想说的是，普通法它特别注重执行。为什么这么说呢？戴雪在英宪经义当中曾经讲过，英国法和这个法国法、瑞士法的区别。你会发现，法国法人权宣言它会列举很多的条文，瑞士也是一样的。今天很多国家的宪法都是一样，它列举很多的权利，但是它很少说这个权利应该怎么去执行，很少说这个权利如果被违反、被侵犯了，然后怎么去落实。但是英国法不是这样。我们从比较早的时候开始，比如说1215年大宪章当中，布莱克斯通把它分成为63条，然后他会用最长的一条，也就是61条，然后来规定我们应该怎么来落实这个大宪章啊，我们应该成立25人委员会，成立4个人的常务委员会来监督国王，然后提出警告，警告不行的话，我们再报告给25人委员会，然后我们再发动民众起来那个攻占国王的城堡什么之类，通过这些措施来保证大宪章的落实啊。所以你看到在1215年的时候，他已经在不光是列举，而且在落实。那么我们后来在很多的制定法当中，我专门研究英国法律史的啊，然后我们会发现很多的制定法都是这样的。那还有一点就是比如说有很多的令状啊，中世纪的令状我们先不说了，它有起始令状，有开始诉讼的令状，但是有很多司法令状是做什么落实的，落实这些的啊，扣押、拘押、逮捕，像这些，它都是为了落实让你来到法庭，然后让那个判决得到落实啊。恒命法当中也有很多类似的这些令状啊，今天大家都很清楚，马瑞瓦禁令啊，然后安东皮勒令啊，这些都是为了更好的使得法官的判决能够得到落实和执行。然后再回到这个戴雪对在英学经义当中的描述，你和他举了很多例子，他举那个是伏尔泰吧，然后他在法国他遭到了贵族请他去吃饭，结果在宴会上鞭笞他，然后羞辱他，他没有任何办法。然后第2次，然后他又把他送进巴士底狱，他没有任何救济办法。然后戴雪说，如果这事情发生在英国，那么他可以申请人身保护令，然后他可以通过什么样的程序，然后获得什么样的救济啊？然后人身保他突出的举了人身保护令的例子，说这个例子他如何可以保证公民的权利和自由啊？他可以在什么情况下可以申请？他自己如果被拘押不能申请，他的邻居可以帮他申请，他的亲人帮他申请，任何看到这种情况的人都可以帮他申请啊。他还举了萨姆塞特的例子啊，也就是那个黑人被绑在泰晤士河的船上，然后有英国人看到了，然后替他申请了人身保护令什么之类的啊。包括我们孙中山然后被囚禁这个事情大家也都清楚。所以我们会看到，我看到的情况是，普通法当然是英国法的本质啊，它非常注重落实。它不是说我光列举这些东西，而是说我列举了之后，我还要说它怎么能够得到落实。那这在如果对应到今天经济的发展的时候，就非常的明显啊。然后如果大家要看，不管是香港还是大陆的这些经济类的案件的话，可能有的朋友可能更了解这些东西一些。 然后你会发现有很大的一些差别。所以这是第二点，普通法它非常注重落实啊。第三点呢，普通法它它可以制约公权。对于企业家对经济发展来说，其实最大的敌人也不是说敌人啊，对手可能不是另外一个企业家，因为如果是另外一个企业家，我们都可以聘用同样的律师，我们可以在势均力敌在法庭上，对不对啊？但是如果是另一个公权力的话，这个可能就不太一样。所以，尤其是在有些体制之下，这个公权力它的立法和行政可能会结合到一起。然后这个立法和司法会结合到一起，他制定了这个法律，然后他又在解释这个法律，那这就是立法和司法的这个结合。所以，那么普通法呢，它在它漫长的历史发展过程当中，它慢慢的形成了一个独立的裁判的这样的一种阵势。那这个是怎么形成的？这是一个漫长的过程啊，不是一天。普通法最早的时候，最开始的时候，法官他也是国王的臣仆 ，servants of the king 啊，他也需要听命于国王，哎，但是我们说从12世纪90年代12世纪90年代的时候，在这个格兰威尔的《论英格兰的法律和习惯》当中，格兰威尔还开篇引用了罗马法的谚语，说皇帝的意志就是命令。但是等到下一个世纪1250年左右的时候，布拉克顿在书中就已经开始说，说国王应该在法律之下，而国王虽然在所有人之上，但却应该在法律之下。啊，不太到一个世纪，你会发现这种观念或者这种趋势就在慢慢的形成。所以虽然有很多的反复在英国法律史上，但是你会发现这是一个慢慢的过程，逐渐的过程，裁判在逐渐的趋于独立。啊，我们还可以举出像亨利八世这样最强力这个权力最大的国王，然后他在通过 statute of use 的时候，然后他怎么和民众和这些普通法律师，然后怎么来进行争辩？那些普通法的律师威胁说，如果你要制定这样的法律，那么我会运用我所有的能力，然后来阻止这个法律的实行。那真的就有律师，然后来解释。后来我们知道，这个法律实际上是被解释成了，它仅仅能够适用于某一些种类的 use， 啊，另外还有4类 use 是不适用这个东西，啊，所以由此才发展出了 trust， 啊这样的东西。所以我们说，我说的意思是，普通法它可以制约公权力，哎，今天它可以审查政府做出的决定，行政决定，在有些地方它还可以审查议会立法的合法性和宪性。那么在英国今天，它可以通过对人权法的适用，说啊，议会制定的这个法律，我们知道在英国制定法律，议会是至上的啊。然后，但是议会虽然可以制定这个法律，但是解释法律的权利却在法官。那这种解释权对这个立法权的这个制约，这是一个非常明显的一个功能。然后人权法，法官可以说你这个制定法跟人权法的不一致，啊，做出不一致的宣告，这样的话我就可以不适用啊。所以在这些意义上，你会发现，司法普通法它不仅可以对行政进行审查 judicial review 啊，而且还可以对立法进行制约啊。那么在这些方面，普通法它保证了一个非常明显的司法独立，然后使得企业家他们能够信任普通法，使得英国人可以信任普通法，说我有问题的时候，我可以求助于普通法，我被拘押了，我被羁押了，我可以申请人身保护令，我必须得经过 due process of law， 然后才可以被 imprisonment， 啊，才可以被剥夺财产，才可以被什么什么之类的。那么这样的话，民众才会有安全感，尤其是企业家，他才会有安全感，他才能够放心大胆的投资，然后他才能够放心大胆的发展经济。那么正是因为有了这样的环境，资本才会来到这里，他才会放心的来到这里。而且我们不管是近期还是在过去， 都听到过很多例子，很多企业家都在谈包括我这个文章里面引用了 Lord Hamblin 去年11月份，然后他做的那个演讲当中提到，那个委员会就是 Bingham 那个研究会，他法治研究会，然后他对很多企业家的那个调查，很多企业家就会认为，如果说出现所谓的法治事件，什么叫法治事件？其实就是企业家的合法权利被侵犯。那么一旦出现这种事情一次，就会有大量的资金撤离，就会开始产生强烈的不信任。那这需要很多时间、很多精力、很多成本来修复。所以我想说的是，普通法它可以制约公权力啊。所以从刚才说的3点，我们可以看到，普通法它不仅可以提供，它可以有助于自由和创新，有助于责任和担当的培养，而且有助于它会特别注重对权利的实施，对法律具体的落实 enforce 它特别注重这个，而且它还可以制约公权力。那么这些都为经济的发展所提供了。你会发现，这个层面上，在我说的这几个意义上，它和 civil law 是很大的不同的。而这个东西是和资金、和资源、和人力、和这些经济发展的因素是不一样的。那些因素是可以替代的，但是这个因素却不可替代。如果你把这个替代了，你的经济就会走下坡，经常会走下坡。所以从这个意义上，我会说，普通法要比civil law 要更有利于经济的发展啊。我大概就说这些，谢谢大家。
谢谢李教授。So Professor Lee, I think, has given us a very interesting class or lesson in legal history and comparative law. He shows that from the historical point of view, how the English common law evolved and developed certain characteristics, such as emphasis on the procedural implementation of rights or the limitation on the powers of government and so on. And he also shows from a comparative law perspective how the continental civil law system and the common law system may have different arrangements, or at least slightly different arrangements on some of the matters he covers. And these matters may be very relevant to economic development and protection of investors' rights and so on. So it remains for me to invite our 2 commentators or discussants to comment on the presentations. So each commentator will speak for not more than 10 minutes. So, and I hope we will leave about 15 minutes for Q&A at the end of the seminar. So, according to the order of our seating, we will first invite Dr. William Wong, Senior Counsel, to speak. Actually, our discussants include 1 practicing barrister and 1 solicitor. So they represent the 2 branches of Hong Kong's legal profession. So Dr. Wong?
Yes, thank you very much. I basically agree with what Professor Wong said and what Professor Lee said. As a petitioner, I want to share with you 3 main points, and then I would give some response to Professor Wong and Professor Lee's speech. The first point I want to make is, with the common law, what does it mean by common law? Why is it called common law? What does common means? All right. Now we'll trace back to the history of common law. Now it was developed in a backwater England, right? In the 11th or 12th century. At that time, Roman law is the high class, respected learning in Europe. At that time, England is a poor village lived by barbarians. Right? Now, the scholars armed with Roman law, right, studied in the continental Europe. They went back to England and they start to apply civil law in various courts. Right? Now, as a result of the application, different results come out from different judges. Right? The same statute, the same wording, different judges interpret it differently. And therefore, for the same statute, a judge in the county court of Birmingham may come up with a directly different result from a judge in Newcastle, for example. And therefore, it creates social chaos, social unrest. Right? It nearly amounts to a challenge to the ruling regime. It's in such circumstances that the king decided to appoint king's judges, right, and to apply common law. Common in what sense? Same statute, same result, right? So you have a precedent basis, right? You have a case base. If a judge of certain seniority decides a case, interpret a case in this way, all the other judges have to follow. It, in that sense, is common. In that sense, it's common. Now imagine if you have to put your money where the system is. Do you want to put your money or investment in a system where, well, the result of this bill depends on who is the judge interpreting the statute? Or a system where you have a web of cases and precedent which binds the hands of a judge, and the results by and large are similar. Now, it is no-brainer. In fact, perhaps Professor Lee can give us more information later. In recent years, the system of case reporting in mainland China has reformed. Now, many reported judgments has not been uploaded. Why? Because same statute, the judges in Sichuan may come up with very different results than judges in Fujian. And why do you want such a thing to be sort of discussed or publicized? So one of the intrinsic value, other than economic analysis, now I have to say that I'm not a student of Richard Posner, so I'm not a fan of his. But one of the intrinsic value of common law is because it embodies the value of fairness and equality, right? Whoever the judge you go to in applying the same set of rules, by and large, you come to the same result. And you have a canon system. Even if the first instance judge is wrong, there's a correcting mechanism. You don't get it right. So that brings what? That brings equality, fairness, and stability. Very stable, very certain. Businessman likes certainty. Certainty, therefore I can plan. Right. So that's the first point. Right. It comes from history. So common law means what? Common to everyone. Not because you are before a particular judge. Therefore, the result is different. So that's the first intrinsic value of common law. Now, the second intrinsic value of common law, which I differ from Professor Lee. Professor Lee says, well, common law is judgment law. Judgment law. Now, most people think that common law is judgment law. But there's a case, a very famous case. I think every law student knows about it. Donahue and Stevenson. Right? Donahue and Stevenson. First case in tort law. Before Donahue and Stevenson, right? If a consumer wants to sue a manufacturer, you can't. Because you don't have a contract with the manufacturer. Private contract. You can't win. And what the consumer lost First, before the first instance judge. Second, before the court of appeal. Because the law was against the consumer. You don't have direct contractual relationship with the manufacturer. But it was a social wrong. How do you correct that? Now, Lord Atkin invented the neighborhood principle, which every law student knows about it, which says that if you manufacture something and you reasonably foreseeable that a consumer will consume it, you owe a duty of care to that consumer. You breach that duty of care, you're liable. Now, then someone say, well, look, this is judge-make law. The law doesn't exist, right? Judge make this law, right? Now, if you go to ask Lord Atkin this question, right? In fact, Lord Atkin has been asked this question. What was Lord Atkin's answer? Because under the constitutional theory, judges cannot make law. The power to make law is rests in the parliament. It's parliamentary sovereignty. So what's the answer? If you ask a common law judge, do you make law day by day? The answer is no. The answer by Lord Atkin is that we simply find the law. The law was there. We didn't make it. We simply find it out for you. All right? So common law is what? Common customary law. It's a custom of the people. All right? And if you go into a room without setting the rules, naturally people organize themselves in a way according to certain rules. Right? No one promulgate them. No one announce them. No one impose them. Right? But people gradually move in that direction. In legal terms, we call convention. Right? But it means that that rule is most efficient for that group of people. Right? And common law just said, we find it. We simply announce it. Right? So the rule, common law rule, exists before it's pronounced. Exists before it's pronounced. So common law arises from facts, not from a law-making institution. Right. That's why customary law. Right. Now, if you read in that base, if you understand common law in that sense, it means that this common law actually fits for people's behavior and economic social activities. Simply to just announce it. I'll give you an example. Hong Kong used to be a very, very vibrant city for cryptocurrencies. Very vibrant. Even South Koreans have come to Hong Kong to trade in cryptocurrency. Because what? Because in Hong Kong, then we have no rules and regulations on the trading of cryptocurrency. None at all. Right. Then the SFC started to regulate it by pronouncing rules. Right. And start to dish out license to operators of cryptocurrency. As a result, the entire cryptocurrency market in Hong Kong just dropped dead. Dropped dead. Right. And the beauty of the law exists according to what people behave first. Not only give the law certainty, it gives the law its life and flexibility. We can change the law, or we can refine the law according to the circumstances and development of economies. Bit by bit. For example, definition of car. That's the statute says that, well, a car. How do you define a car? Right. Now we have cars which actually can fly. Does that qualify as a car? Right. Now, there's a recent judgment in Hong Kong defining whether cryptocurrency is a property, whether it is a property or not. right? And Hong Kong court has no difficulty from the view that cryptocurrency is a property. While leading scholars in Oxford Law School and Hong Kong U Law School are still debating on the topic. As the French says, these tools work very well in practice, but it work in theory. So common law have a very pragmatic root, and therefore it fits people's mind. Right. That's the second point. Now the third point. Now, common law doesn't make you easier to evict tenant. That may be ex post facto, right? Something that happens. In fact, I was just having a dinner with a Cambridge legal professor in City University Law School the other day. He specialized really properly. He told me that England is going, under Labour Party, is going to enact a law that you cannot evict a tenant for a short lease. Right. And I asked him, what's the definition of short lease? Oh, anything less than 7 years. So 7 years is a short lease. Right. Now, but there's one beauty, and that brings my third point. There's one beauty of common law. Is this. Common law adopts a minimalistic approach. I tell you what you cannot do. Right? I tell you what you cannot do. I draw the red lines. Other than this, you are free to do whatever you like. I tell you, this is what you cannot do. But civil law is very different. Because civil law is designed by a class of very intelligent scholars. Right? They may have an IQ of 200 or 300. Right? And they want to set out all the eventualities of situation. Right? Therefore, you look at mainland China's civil code, right? Recently promulgated in 2024. Right? It's that thick, the civil code. Right? And you can always find causes that under such situation, so the court should support this result. You can never find such expression under common law. Because common law will never tell a judge what you should do. Right? Common law merely says the minimum parameter. It's the game of chess. These are the rule game, ground rules. On top of that, you can play the game in whatever way you like. We do not set moral standards. Right? We set minimum ground rules. Right? So common law does not try to envisage endless possibilities. And we develop that according to the circumstances. So I think it is in those features, those intrinsic value of common law, you put yourself, right, applying Professor Ross, the theory of justice approach, that you are now a cell, right? You are about to be born in a system, right? Which system do you decide to be born into, right? Then you would know that, well, if the common law system is the one that you want to be born into, then you know where the money is to flow. And if where the money is to flow, then where is the financial center? Right. So I think that is the intrinsic value of common law. Thank you.
Okay. Thank you, Dr. Wong, for sharing your insights about the nature of the common law. And last but not least, we'll return to Mr. Rico Chan. Whether you're going to share your experience from a practicing solicitor's point of view or any other point of view.
Thank you, Professor Chen. Now I have actually prepared a few points, but given the limited time, I will cut short so as to allow more time for discussion. I will, generally speaking, I am in very high degree of agreement with Professor Lee on his way of describing the key attributes of common law legal system. And except for one point, which I am still considering, and his point about common law legal system actually encourage citizens to be more responsible for their own behavior. So this point I'm still considering. But that was a point that where I was on Professor's webinar several months ago that got me very intrigued, apart from his other very profound analysis of the basic foundational attributes of common law, which I, as a practicing solicitor for many years, was not able to spend too much time to ponder upon. Now, also for a side comment, for proper kind of record, I'm no longer a practicing solicitor. I practiced for 35 years. I fully retired from the as a practicing lawyer about 18 months ago, and now a non-practicing solicitor. Don't take me my comments as like legal advice, because I'm not qualified anymore. So it's more academic in nature and intellectual in nature. So on the point about, I will comment on three aspects. One is actually I had the opportunity to read about Professor Lee's paper, and he actually did not mention about one point, maybe due to limited time, about is common law, or are these common law attributes actually necessary but not sufficient factors for economic development or for development of financial markets. And I would agree with that. His comments, these are probably necessary but not sufficient factors. As far as the case of Hong Kong is concerned, that is consistent with my own observation. For example, I think by the time the financial investors came to Hong Kong in a big way in the late 1980s and the early 1990s, Hong Kong as a legal system was already ready. Hong Kong has a common law style rule of law system, very high degree of judicial independence, and a basically largely corruption-free society due to the good work of the ICAC. The legal system is ready. The lawyers were ready because I'll elaborate on one point, and this is something that Dr. Wong would be a lot more familiar as advocates and barristers. Is the case law method of training lawyers. Because as law students, day one, we were required to read cases and cases and cases to really understand, extract the crucial facts, try to find the correct legal principle from the cases, and be able to write out very cogent, persuasive legal reasonings to justify our conclusion. So I'm not saying that civil Continental system do not train their lawyers like this way, but my impression and experience is that, at least for China, a common law case law way of training lawyers and their lawyers and the students are quite a bit more rigorous in this regard. And that means basically we are very well trained to deal with the reality, not theory, not concepts, but actual case of facts and how you deal with the problem in front of you. So that's the legal process already. And I think there are several, how come Hong Kong financial market became its current state of scale and level of success that we have? I think there are several very significant luck factors. For example, we have common law system. We speak English, use English for our operating of our system mainly. Who were the financial investors? Where were they from? They were from the US. They were from the UK primarily. And even if these companies were from Germany, France, or Japan, their executives were very used to the common law way of operating finance. So when they come to Hong Kong, they feel very comfortable, and we are able to explain things and be able to draw up legal analysis, advice, documentation, and risk mitigation plans to make them comfortable to commit significant capital for China investment, whether through Hong Kong or not. And in fact, most of them do it through Hong Kong. So Hong Kong benefited. And that was how without the China opening up, Hong Kong would not have the financial market that we now know of. So then finally is the true luck factor. Luck factor is China opening up. All the common law factors would be necessary, but not sufficient, and it won't happen. But for a Chinese government decision to open up the economy and to attract capital to China in 1979 and onwards. And I'll give you an example. And the scale of that possibility was so huge that international investors are prepared to be patient and prepared to spend time and resources to juggle, to figure out the way forward, together with the Chinese government as to how to get the best return out of the investment. A specific example is when I was the junior team member of our team in 1992 to do this first B share listing on the Shenzhen Stock Exchange of the company called China Southern Glass. Guess what? At that time, there was no company law at all. You can list the company without company law. At that time, there were only several documents from the China System Reform Committee, policy document as to how company and listings will operate. A few short documents. But everyone, the investment banker, Chinese government, the local stock, all work together to make it happen. And the rest was history. So really is the big scale that of the opportunity that make people are prepared to work it out. And then I found out I will just comment on two minor points. One is about overall, it's consistent with Professor Lee and Dr. Wong's comment. The common law has a goal system. In a nutshell, its goal is to protect individuals' right or companies' right. And what is that right? I think one of the very important is the right to protection of your money and your assets. And in the capital world, as we know it, UK, due to its maritime military power and industrial revolution, was able to accumulate a lot of capital to invest and develop this capital market. So overall, the capital market was able to develop most significantly in UK and the US. And it was part of the reason, and also because the common law has that goal of protecting the right. And like Dr. Wong said, common law has been very flexible to achieve that end goal. And these systems have been consistently doing so for decades and for centuries and centuries. And finally, just one comment on Professor Wong's comment on about a 15-year plan for Hong Kong to be financial investor to mobilize capital. I think we are talking about that version of 2.0. The 1.0 happened when we were getting like the Qingdao Pier and other like big share listed in Hong Kong, attracting capital in China. Now, I think we would do it in a way where basically we will use Hong Kong to mobilize renminbi capital for operation not only in China, but worldwide. And that is a new version of financial market that we need to work together on. Thank you.
Thank you, Rico, for sharing your experience. I think your long experience as a practicing solicitor makes you very well qualified to speak compared to a relatively junior solicitor. So I think there's no doubt about it. So now we will open the discussion to the floor. So members of the audience here are welcome to give your questions or comments. And if I can see whether there's any question online, I'll also take some of the questions. So maybe we'll start from my right-hand side and then we'll move to the middle and then to the left. Yes, please.
So since you speak Mandarin, I will speak Mandarin and I provide an English overview. I'm Jonas Sibani. I'm a first-year law student in the British Open University. 我叫徐恩纯，我是英国开放大学的法律系大一学生。在我小时候， 3年级的时候我就能读刑法，5年级的时候我就能读中国的6法全书、商法、合同法，一切看起来都很容易。In China, law is really straightforward. I can do that in primary school. Everything seems easy. But in Hong Kong, 但是在香港合同法你也知道，7T on contract 一套16000，7T on contract， $16,000 dollars, really long, really complicated. So in your opinion, you said common law is
对不起，或者你用中文把你的问题简单的讲出来。
好的，您说普通法是一个比较重视执行、比较重视灵活立法的一个 jurisdiction。那但是呢，会不会在普通法法系里有一些过度执行的情况？比如我在广州租房子，我只需要签一个字就可以。我租房子哦，侵权法那么厚，合同法那么厚，各种还有 concept 的 bylaw 之类的，我要签那么多东西，然后双方都有很多的合规成本和法律成本，所以您认为这个普通法会不会我知道它在以前很好用，但是在未来它会不会过度立法，然后阻止经济的发展？谢谢。
谢谢。Maybe I will take a few questions, collect them together, and will then ask each speaker to respond because time is very limited. Anyone on the right-hand side? Yes.
Hello, every professor. And I'm Mikey. I'm a law student at HKU. I'm a master, and I have two questions. One question is for Professor Lee, and one question for Dr. Wong. For Professor Lee, my question I speak in Mandarin. 您刚刚说普通法是量体裁衣，普通法它是选购成衣。我想请问一个细略的问题，就是去做衣服的人，他是光着身体去做衣服的吗？还是说他是穿着衣服去做下一条衣服的？第二个问题是所有的人都有时间去等待一套做衣服的时间再去穿衣服吗？还是说有些时候有些领域需要一套能够像现在175、180这样立刻就能穿上的衣服，更适合某些人的需求？有些人他喜欢高定，他喜欢全身定制，他可以去选择量体的定义。所以这两种仅仅就衣服生活的方式来说，是不是各有所适合的方式？因为人有不同的喜好，他们俩是互补的，不一定有高下之分。这是对Dr. Lee 的问题。对 Dr. Wang 的问题。I'm here and I have a question for Dr. Wang. Just now, I think the advantage you say about common law, most of them, I think, is not an advantage of common law. It's about separation of power. You know, just because separation of power and the power of administration has been limited, and the judicial power can assess and review the legislature, the act and the legislation of the legislature, the action of administration. I think because of these separation of powers, the judicial power is good. And in most countries who are not in such kind of regime, legal regime separation of powers. And I do believe maybe just like in an about case, say a case in Sichuan have a different result with a case which is reviewed in another province. But how do we to identify the same case? The same person? Of course not. The same every details the same in these two cases. Maybe you think the important details in these two cases are identical, but maybe the judge think the details in all of the details in the two cases are not so identical. So, how to define? That's the right to define. Is how to define? It's you, me, us, or the judge. Try this case. It's my two questions. Thank you very much.
Thank you. Maybe people from the middle. Yes, please. First the lady, and then So we'll take three questions from the middle. So first the lady.
Yes.
Isabel.
Yeah, thank you. So my question is for all the speakers. So my question is about the convergence of two systems. Convergence of two systems. So we can see that many common law principles are now written down in our legislation. And in Hong Kong, So do you see this integration or convergence happening in the near future? Thank you.
Yes, the gentleman in, yeah. Please.
To 1937, Hong Kong is proud of common law usage, but now we will consider the deterioration of common law system or application in Hong Kong, which will likely deteriorate the financial center, the status of financial social center in Hong Kong as well as international. And if so, how can we amend or remedy this deterioration to maintain our common law system in Hong Kong so as to maintain our financial system internationally? Thank you.
Thank you. So maybe here the last question from this gentleman.
Yeah. Today we are to explore the linkage between legal systems and economic performance. I venture very succinctly that there's a missing link in the varieties of capitalism literature, that there's actually a high correlation between legal systems, common law, civil law, and between liberal markets economy and continental market economy. And if we broadened the discussions to the overall institutional economics framework, institutional environment is level 2 based on Williams and four layers network, 4 layers framework. Governance, VOC, is level 3. So the LOT theory is the ultimate cause transmitting through level 3 VOC to performance. So, and these 2 layers, LOT and VOC, are mutually reinforcing, hierarchical. And I think we can more fully understand and to some extent validate the causal effect of LOT through a lower level, level 3 in VOC governance. Thank you.
I suppose since you used quite a lot of abbreviations, I'm not sure we understand your question. So can you, in 2 sentences, summarize the question and without using the technical terms and abbreviations?
Well, it's hard for me to further compress because actually varieties of capitalism is a highly established framework within comparative political economy. All I'm saying is for us to elucidate and understand the linkage of today's framework, which is how legal systems translate to shape economic performance, we can only understand that fully if we incorporate the varieties of capitalism literature as the mechanism or linkage between the legal institutional layer and the performance layer. Thank you.
So your paper is about the varieties of capitalism, is that right?
Yeah, it's a very famous framework, varieties of capitalism. Yeah, Hall and Soskins, yeah.
Okay, thank you. So since we don't have too much time left, may I suggest that maybe we reverse the order of our speakers? So we'll ask Rico to say anything you want to say in response to the questions, and then we'll pass to William, and then Professor Lee, and then Professor Wong.
Okay, I'll try to be brief. Worry about deteriorating common law in Hong Kong. I don't take that view. I think Hong Kong common law continue to be, at least definitely on the civil and commercial space, continues to be very robust. I think Dr. Wong can speak more competently on this issue. On the issue of convergence of the 2 systems, it has been happening. I would like to see China to be able to incorporate more of the case law methodology in training its lawyer. And we discussed this in a conference in Guangzhou over the weekend together with Professor Lee, with other professors. On the issue of a variety of capitalism, I speak to capitalism. I would just say in a conference about maybe 8 years ago in a hotel conference. I was talking about termination of contract by a hotel manager against the hotel owner asset. A gentleman stand up and yell at me, said, Rico, as a lawyer, you don't have enough respect for capital. So Hong Kong, so common law system, UK and European represent, they are inherently very supportive of capitalism, even the very strong form of capitalism. And the legal system work around flexibly towards that goal. Thank you.
Thank you. William?
For the two specific questions for me, one is on separation of power, whether judicial power is very important for common law. Now, this itself can be a topic of 3 hours lecture. I remember my second essay in my first year's constitutional law. Professor Chan is an expert in constitutional law. I wrote an essay called Separation of Power is a Myth. Full stop, please discuss. Right. Now, you will know that there is no such thing as a clean separation of power in any legal system. At the end of the day, even in UK, the head of the judiciary, in the old days, Lord Chancellor, is a political appointment. It's appointed by the cabinet. And then the Lord Chancellor then appoint various judges. Right. So it's not about, I don't think it's not about separation of power. It's about a cultural check and balance between various functions of government. But we can debate that for a long time. But basically, no system in this world has separation of powers, simply none. Right? It's a matter of degree and check and balance. Now, your second question is, same cases, how do you decide which part is the same, which part is not the same? No factual case is 100% the same. Then it goes back to the basic techniques of studying cases, which is in every single case, your law professors will teach you, can you identify to me what's the ratio of this case? What's the legal principle decided in this case? The facts are unimportant. It's what is the legal principle that's specified in this case. You want to cite a case in court, the first question I will ask is, before you launch into the facts of the case, can you tell me what's the legal proposition that you want to rely upon? So a good lawyer, a good law student has to be able to identify a legal principle from a case. You apply that legal principle across the board. That is what we call decide cases on the same basis. And you're going to examine, I think, by Professor Chan or every professor in Hong Kong, you're giving you problem questions. All right. And you apply the legal principles or the ratio in the case. All right. And you know the distinction between what's the ratio and what's the dicta. Right. And ratio is essential reasoning, dicta is non-essential reasoning. That's the technique of distinguishing cases. And that's the technique you have to learn in law school. Now, the third question is convergence of two systems. Again, that's an age-long debate. And I think in Hong Kong, we do have statutes. We have many statutes actually codified common law. In fact, codification of common law is an ongoing process, even in the States. There's so many codification going on, right? But life goes on, new problem pops up, and new principles has to be developed. And the codification is always lagging behind. It's always lagging behind, all right? And therefore, there's always life to common law, right? Now, finally, there's the question about deterioration of the common law system in Hong Kong. Again, I don't understand the basis when you say that there's a deterioration of the common law system in Hong Kong. Now, I practice in the common law system in Hong Kong. I earn my living in the common law system in Hong Kong. Honestly, the common law system in Hong Kong, in my honest view, post-97, is actually much more vibrant than pre-97. And just look at the quality of legal teaching in this law school. So I think we shouldn't have a psychology that our forefathers are greater than us. In fact, we should have the courage to say that we are going to be better than our professors. And I hope that the law students in this faculty will say that, well, I will be greater scholars, greater lawyers. And it's people that make the system great. And I have every confidence that with a great law school like this one, you are going to make the common law system in Hong Kong very vibrant. So I'm not afraid at all of deterioration. Thank you.
Thank you for your encouraging words. 李教授看一看你有什么建议？
第一位提问者说过度执法的问题哈，我想可以分成这么两种情况，一种就是说在普通法当中，在普通法国家当中，它其实司法我认为它的效率还要更好一点，因为它把这个司法分成了基层和高级的法院的司法啊，基层法院的司法就像magistrate court， 然后它处理的效率会很高的啊，会之所以说有像你所看到的很多合同，那是因为普通法它是基于在后来，而基于一个商业社会形成的。那么如果确实是因为商业它要求确定性，所以它签那么多的东西，可能是也是可以理解啊。但是我相信，就是说有不同类型的案件会被分流到不同的层级的法院啊。如果要是例行的案件、简单的案件，可能下面的法院处理会很快就可以处理好啊。只有说是碰到了特别疑难的案件，然后才可能会到上面，然后我们进行充分的 argue， 然后才会得出相应的这个结论来或者规则来啊。所以我想这个问题应该不是一个很大的问题啊。第二个提问者说去做衣服的时候，没有人会赤裸着身体去啊，这个说法很有视觉冲击力，但是我觉得这个说法其实对我们这个讨论这个主题来说并不关键，我只是把这个去做衣服的人当做视为一个他需要衣服的，然后这是一个纠纷，他需要一个解决方案啊，所以他赤裸着衣服来还是不赤裸着衣服来，我并不关心啊，但是在我给他量的时候，我一定会非常的贴着他的身体来量，这是毫无疑问的啊。第二个，你提到所有的人是不是都需要量体裁衣，这就是我刚才提到的。如果是 routine cases， 司法法官一上午可以处理20个、50个都有可能，因为他只需要遵循先例就够了啊。但是有一些 hot cases， 他可能确实是需要反复的斟酌，我需要给他量体裁衣。那例行案件是不需要量体裁衣，那衣服已经是显而易见的啊。所以我们要区分这，如果我们区分了 routine cases 和 hot cases， 那我们就能理解我为什么说量体裁衣这个事情。谢谢。
May I invite Professor Richard Wong to give his general response?
Very quickly, I just like to say something. I prepared this, and I had one part that I did not think I should present because I know that it was not enough time. But I would like to point out that some of you might be interested. I was going to talk about the first 12 pages of a very short book. It's called An Introduction to Legal Reasoning by Edward H. Levy, published in the 1940s. Levy is personal to me because he was the president of the University of Chicago when I was a student. And he had the habit of inviting or asking people to invite some undergraduate students to have breakfast with him in the first week of starting. And I was very fortunate to have met him. He was quite kind. And because he was a law professor, I went to look for the book he wrote and I bought it and I read it. That is probably the only thing I've read written by a lawyer. Professor Levy, to his great disappointment, was never appointed to the Supreme Court of the United States. Instead, he became Attorney General during President Gerald Ford's time. So he would rather have been a Supreme Court Justice rather than Attorney General. His very short book is a brilliant exposition of common law and the doctrine of precedent. If you read it, you will understand deeply the common law. As I, being not a lawyer, really admire that book. So I recommend it to the students. You don't have to buy it. Go to the internet. You can search it. It's so long. It's download for free. I just like to, is there convergence between the two systems? And there is. It's inevitable because countries trade across legal traditions and jurisdictions, and therefore they modify each other. That's one reason. Another reason why there is some convergence, and that is legal systems cannot solve all social problems. And therefore, you have government, the state, come in. And in so doing, they have adopted statute laws of various types to do social re-engineering. So common law systems have taken on more practices that look like continental law, civil law systems. So there is convergence, but so has civil law, continental civil law systems taken on common law because they have to trade with common law countries and foreign investment, financial. So there is convergence, but the convergence does not obviate the sharp differences between the two systems, right? If it had been obviated, its impact on economic performance would have converged. Convergence is very slow, slower than the ice in the Arctic Ocean will melt. History has shown, and in this, I would also like to, and therefore, implicit in what I just said is deterioration of common law system in Hong Kong is highly likely, but it will move so slowly that your great-great-great-grandchildren will still recognize it. Finally, on the varieties of capitalism. There are varieties of capitalism. See, as a social scientist, you would like to see there is legal origins. There is varieties of capitalism as a concept. These are all concepts. There is also the issue of the state. There are many different types of states. Developmental state, neutral referee state. And then there is also something which I would call political systems, democracies, autocracies, what have you. When you begin to examine the concepts associated with these four ideas, and I do not want to go into a long social science analysis, but if you look at the empirical data and you test it, and you begin to see who explains what. And it's so amazing that legal origins explain so much that the other things are rendered largely irrelevant. Because legal origins are so stable, it's so difficult to change. You have so many law judgments. How can you overturn it without society getting into turmoil? So you have to follow it. You know, what was decided 500 years ago, you have to follow it in 400 years ago, and then 300 years ago, and 200 years ago, and 100 years ago, and last year. So it doesn't change very much. So of all the concepts like political systems, the state, active versus passive state, varieties of capitalism, it has been found in empirical analysis, legal origins is the best exogenous variable rather than the others. Political systems change much faster than legal systems. And that is why legal origins is so important and why Hong Kong is so lucky not to have been a Portuguese colony. Right? Otherwise, we wouldn't have any advantage. We would have become like Macau, and we will be the greatest casino. instead of the very orderly financial markets. It does not mean our financial markets cannot be improved. It's still pretty poor compared to price earnings ratios on New York Stock Exchange and NASDAQ. That means our financial market is not very good. But that means it can be improved a lot more. Indeed, unless you improve it, you will not be the financial center for financing China's future. The opportunity is there. We are coming short, but we have some inborn genes, and I call them genes, that make it very important. Thank you very much.
So let me thank, first of all our distinguished speakers this evening. I think they all helped to enlighten us a lot about the common law, civil law, and economic development, and Hong Kong as an international financial center. This is an important topic, and we hope we'll organize more talks and seminars in the future to explore the topic. So thank you to all of you here, and thank you for the audience participating online. I'm sorry that we don't have time to take some of the questions online, but we hope that in the future we'll have the chance to explore these issues again. So thank you very much, and good evening to all of you.